Hi, I'm Mady Olivo. Welcome on behalf of the board of the Sports Lawyers Association. This is our first joint webinar with the Japan Sports Lawyers Association. We welcome you, and I'm sure you'll enjoy this webinar. So I want to remind people to renew their memberships to the Sports Lawyers Association, because our memberships just expired March 31st. And of course, non-members, if you want to join, please do so at sportslaw.org to take advantage of our great benefits like these webinars, our outreach events, the Sports Business Daily, one of my personal favorites, and of course the annual conference, which is coming up live and in person for the first time in 2 years on May 12th to 14th in Atlanta, Georgia. And if you're so inclined, follow us on Facebook or Instagram or Twitter or LinkedIn. And on sportslaw.org, there's a lot of great content. So I want to turn this over to the moderator of this panel, Takuya Yamazaki, and enjoy, everybody. Thank you for joining.
Thank you, Mady, and hello, everyone. My name is Takuya Yamazaki, the Secretary General of the Japan Sports Law Association. I'm really glad to be here to moderate this panel. Because, as Mady said, this is a very first inaugural joint webinar between by SLA and the JSLA. Thank you for joining us. So today's topic is how the CAS Ad Hoc Division was conducted under the pandemic. This is really interesting topic, and we as a sports lawyers are always curious about what happened behind the scene. So we have very fantastic panelists today. So we have 3 panelists today. So 2 are from Japan, and one is from, are you in London now, Jeff?
I am in London, but my heart is in Japan.
Oh,
Gaijin.
Okay, so you can talk about your experience in Japanese throughout this webinar if you want. But anyway, Mr. Shoichi Sugiyama was the one who operated the pro bono lawyers program in Japan at the Tokyo Olympics and the Paralympics. And Mr. Somiya Matsumoto was one of the representatives or the lawyers who actually represented one of the parties involved in the CAS Ad Hoc Division. And Jeff, obviously, as you all know, established a sports lawyer and a CAS arbitrator. So I need to learn a lot from you, Jeff. As a CAS arbitrator as well. But anyway. What I'm going to do is to give you the floor, Mr. Shoichi, to talk about your experience at the Tokyo Olympic and Paralympics, especially in terms of actual operation of a pro bono lawyer program. So Shoichi, the floor is yours.
Thank you, Takuya. Nice to meet you. Good morning, good afternoon, everyone. I'm Shoichi Sugiyama, a qualified lawyer of Japan and also case manager of Japan Sports Arbitration Agency. I personally am one of the member of Pro Bono Management Committee for the Tokyo game. So today I'd like to explain briefly about our activity at the Tokyo Games. So I share my screen. So we, Japan Sports Arbitration Agency, mainly provide arbitration and mediation service for sport-related disputes in Japan. But also we researches the system of sports arbitration in foreign countries. So in early stage, we have researched the pro bono activity in London 2012 games. So we JSA started to research or planning to provide pro bono service since 2016. The objective of this service is to contribute smooth management and operation of the Summer Olympic and Paralympic Games. However, also Japan is unrepresented country about the international sports arbitration. So we JSAA would like to utilize this opportunity to promote international sports arbitration during among the Japanese lawyers. In this service, we set two sections. One is general section. The two is advocacy section. General section provides legal service on domestic legal issues. Because Tokyo Games is under the COVID-19 strict rules, so we have no cases on general section. However, we have several cases in advocacy section. This service is operated by management committee, which consists 6 lawyers and academics who has expertise on sports arbitration or international arbitration. It drafted the operational rule for the service. And we, Japan Sports Arbitration Agency, played a role as a secretary offices, and also we conducted several international conference or seminar or domestic seminars for the candidate lawyers. The problem is we confronted with the postponement of the Tokyo Games. So we started this project March 2019, and in total 140 lawyers appointed as the candidate at first. However, due to the postponement of COVID-19 in March 2020, our project is also suspended. And around December 2020, we have newly restarted this project, and we successfully provide our service between July 13th to 8 September 2021. This is 10 days before the opening of CAS Ad Hoc Division and a closing ceremony date of Paralympic Games. The result, we have 3 cases of which a pro bono candidate was appointed for the advocacy section. And one of the today's panelists, Miyamoto, is the candidate of first cases. This is the selection dispute between athlete and NOC of St. Christopher Navies, which is detailed explained by Mr. Miyamoto. And second case is the eligibility dispute between Georgian athlete and Georgian NOC. And the third case is maybe the most famous case during a Tokyo game, the dispute between Belarusian athlete and Belarusian NOC. So through these cases, in total 6 lawyers were appointed. This is the result of our pro bono service. Maybe the participants have many questions, but today we have to expertise panelists. So I finish my presentation. Thank you so much.
Yeah, thank you very much, Shoichi. And so I forgot to mention that those who joined this webinar, you can just put a question in the chat box, and we will pick up some of the questions later. So please feel free to write in the chat box if you want. So Shoichi, the first question from my side regarding the actual operation of pro bono service, and obviously the Tokyo 20 Games has been postponed due to the pandemic, and I was also involved in the Tokyo 2020 organizing committee, so I faced a lot of difficulties due to the postponement. But how did it affect the actual operation of a pro bono service? Because many of the candidates were actually expecting to be at the game time in 2020 rather than 2021. But so did you see some of the candidate lawyers, left from the framework or something like that?
Good question. As I have explained at the beginning, in total, 140 lawyers were appointed as a candidate. However, due to the COVID-19, finally, we have 30 lawyers for advocacy section and around 40 lawyers for general section. This is because one reason is we couldn't provide any prevention measures for candidates on COVID-19. So some of them can't help but to quit as a candidate. And another lawyer, so around the games, the holding of Tokyo Games were criticized by Japanese students. So for some of them, it is difficult to cooperate our project. Unfortunately, some of them can't help but to quit our service. And another problem is, so we do not expect Tokyo Games is held under the COVID-19 situation. And athletes are under the bubble. So maybe the candidate, Mr. Miyamoto, were totally uneasy how to help or support the service under the bubble situation and how CAS hearing was operated during the game. Maybe he was so uneasy about the issue.
Yeah, that's really kind of an interesting thing because I think you made two points. The first one is this kind of branding of Tokyo 2020 games, because many of the lawyers who wanted to be involved in the games or the services was because it was supposed to be a privilege for them, right? So or honor, but actually, due to the massive criticism by the media against the Tokyo 2020 games, many of them kind of gave up or didn't want to be involved in the Tokyo 2020 games. This is really
exactly
kind of interesting kind of a phenomenon. And on the other hand, in terms of actual operation, you said the bubble in the services, but of course, Japan is one of the kind of unique countries in terms of I would say overly conservative against the pandemic. So I live in London, but I'm in Japan right now, and I'm always kind of wondering why many people are always wearing masks even outside, because I can't see anyone who wear masks outside. So right now in London. So, but having said that, due to the conservativeness, of course, I thought, or I assumed that you as an operator has set up a very, very kind of a secured system for lawyers or the people involved in the program, but actually, people involved in the program were not really happy with the system prepared by the service operators, right? So yeah, that's really kind of an interesting thing. And also this is a really good segue to Mr. Somiya Matsumoto. Thank you for joining us. So you actually represented one of the parties of the case. So I'm going to give you the floor to explain the actual case and your experience in the case.
Thank you, Taku. My name is Somiya Matsumoto from Tokyo. It is my honor to have such opportunity to be a panelist at this seminar and discuss Olympic-related dispute with Mr. Benz and Mr. Sugiyama and Taku. I was a member of the pro bono service project duly managed by Mr. Sugiyama at the 2020 Olympic Games. And fortunately, I had a chance to be legal counsel to a swimmer from St. Kitts and Nevis for the CAS Ad Hoc Division. This is the reason why I'm here. My case is first arbitration case for 2020 Olympic Games. My co-counsel and I were appointed to be legal counsels to a swimmer from St. Kitts and Nevis. As you may know, St. Kitts and Nevis is a tiny island country in the West Indies. The time zone of St. Kitts and Nevis is the same as EDT. So you can easily imagine the time difference between Japan and the country, like today's seminar. This time difference is very relevant to our case. I will talk about that later. The swimming population in St. Kitts and Nevis is very small. The athlete, our client, has been trying to increase the popularity and the number of swimmers in the country for several years. In addition, as a representative of St. Kitts and Nevis, she had participated in several international competitions, including the World Swimming Competitions in 2019. Even though she didn't meet the standard time to participate in the Tokyo Games, FINA duly approved her qualification to participate in the Games through the universality place on the condition that St. Kitts and Nevis Olympic Committee send her Olympic application to the IOC. The meaning of universality place is that an NOC with no qualified athlete is allowed to enter their best ranked male or female athlete into the Olympic Games. But SKNOC decided not to send her application because St. Kitts and Nevis Swimming Federation wasn't affiliate of the SKNOC. And then our client was dissatisfied with this decision because she believed that SKNOC used its power arbitrarily and unfairly. So she filed for arbitration using our legal aid. But in the end, her petition was dismissed because we didn't show sufficient evidence to prove that SKNOC abused its authority and treated her arbitrarily. So that's a big picture of our case. And I'd like to explain the timeline of this case. Since the athlete, our client, is in Canada at the time of the filing, and we firstly contacted the applicant on July 15th, and she wanted to participate in the women's preliminary 100-meter backstroke on July 25th. So it sounds like we had enough time to prepare for the filing. But there was a quarantine requirement for foreign athletes. Due to the pandemic, the Tokyo Olympic Committee established the playbook for athletes. Under the playbook, 2020 required foreign athletes to have self-quarantine for 3 days upon her arrival. So due to this self-quarantine requirement, we feel strong pressure to file for the arbitration immediately and obtain the award as soon as possible. So, and we filed for arbitration around noon on Sunday. So we prepared Friday night and Saturday and communicated and email exchange with the client. And so I should have mentioned our client has dual citizenship in both Canada and Saint Kitts and Nevis. So originally she is a Canadian, but she worked and lived in Saint Kitts and Nevis for several years. And so when we filed for arbitration Sunday noon, we knew there is a rule to deliver the arbitration award after the acceptance of the petition within 24 hours. So we took advantage of this rule to get the award as much as possible. But we were not quite sure of when the specifically the time limit start. But fortunately, in our case, the CAS Ad Hoc Division accepted our case the same time as I sent out the application through email. So the time clock started 11:55 a.m. On Sunday. And the application was sent to the Saint Kitts and Nevis and other relevant parties at 3 p.m. On Sunday. But for respondent, especially for Saint Kitts and Nevis Olympic Committee, it was 2 a.m. On Saturday, their time. And the hearing date was set on Monday morning, our time, but it was Sunday night, their time. So at the beginning of the hearing, and the SKNOC filed a request to postpone the date of the hearing because they didn't have time to prepare for the filing. So it sounds like their claim reasonable because they didn't have time actually. But in response, we argue that SKNOC should have expected this dispute based on the circumstances. Arbitrators decided not to postpone the date of the hearing because any NOC should prepare for the dispute, especially arbitration during the Olympic period. So this is a special circumstances that requires NOC to stand by anytime. So the hearing started without delay. And we had virtual hearings and counsels and representative from FINA and arbitrators participated in person from Tokyo. And in the end, our petition was dismissed, but the award itself was delivered on Monday night. So we successfully obtained the award, but even though our petition was dismissed. So that's a big picture of my case.
Yeah, thank you, Mr. So this is really interesting because, of course, under the current CAS Ad Hoc Division rules, of course, the panel is needs to deliver the decision within 24 hours in principle, right? But due to the time difference, it can be sometimes really detrimental to the other parties in terms of a procedural justice. So I'd like to give you the floor, Jeff. Of course, you're going to talk about you're going to talk about your experience in Beijing, but just looking at the particular case in Tokyo, which So mentioned right now, how do you see this kind of a procedural, the procedural, consequence, like in terms of the especially in terms of the managing the time difference or the in terms of the procedural justice? How do you see this case? Was it really kind of a injustice, or was it is kind of a inevitable, or how's your opinion?
Was this for me or for?
Yeah, Jeff. Yeah.
So I think that one of the things we've learned about sport arbitration is that the main defining difference between us and everything else in the world is time matters. And you can you pick a movie, the American epic Gone with the Wind, or any other movie you want to say, and it always ends the same way. Time doesn't matter for that. But for sport, sport doesn't stop just to accommodate the passage of time. And so I think that the conflation of schedule, time, and everything else is an important attribute of the sport dispute resolution system that people have to understand. It's different than commercial arbitration. It's something that even when you have the most emergency of cases in international commercial arbitration, let's talk about like eggs spoiling on a dock somewhere, you still have days, maybe weeks. And in the sport context, you have hours. So in my case in Salt Lake City, where I was general counsel of the USOC and I was still able to be a CAS arbitrator and represent athletes and others participating in the CAS dispute resolution system, we got served at 3:00 on day one, and we had our hearing at 10:30 p.m. So 3 p.m. to 10:30 p.m. A very conflated schedule, and we had a ruling by 7 a.m. the next day. And that's just the nature of it. Time does not stop to allow sport to work out its problems. The schedules exist to benefit sponsors, broadcasters, other athletes, people that are training that need to know when the event's going to occur. And that's a big difference. So that's just a general reflection on this. I'm happy to share stuff about Beijing or other things if you want, but you let me know.
Yeah. That's really kind of a perfect answer to to my question, because this type of things can anyway happen all the time, right? So even of course under the pandemic and the many of the relevant parties or stakeholders are outside the game or the venue or in the country which the game takes place. Those many of the relevant parties or relevant people have to react even in the midnight. So that's the nature of ad hoc division. So that's, I think, the point of your answer. So let me just ask you, Mr. Somiya Matsumoto, based on your experience, of course, now, thanks to the technology, we can conduct the procedure online, even hearings. So, but how did you see the procedure? So, especially in terms of using technology in an effective way, or in terms of the securing or guaranteeing the procedural justice or fairness. How did you feel about the actual operation of this particular case?
Yeah, the operation of this case was perfect. I didn't feel any difficulty, but I thought it was good for us to participate in person, because we had a chance to exchange greetings with the arbitrators in court, at court. This case was my first sports arbitration. So honestly, I was a little bit nervous. But when I exchanged greetings with arbitrators, they knew we were pro bono lawyers. So I felt the welcoming atmosphere from them. And they said such like that, you are the pro bono lawyers, I've heard of it. So this welcoming atmosphere helped me to perform well at the court.
Yeah.
So Tak, let me intervene something interject
Sure.
something for our American audience. So the Japanese bar exam to become a bengoshi it's gotten easier lately. It used to be like a less than 5% pass rate, and multiple social issues that arose out of that. But now it's gotten up around less than 20%. Anyway, it's one of the hardest bar exams in the world. And to have these guys operating on a pro bono basis in the context of serious legal issues, legal disputes, is dramatic. It's important, and it's the kind of thing that the Olympic family needs to embrace and be conscious of, because ultimately, at the end of the day, that there are only so many people that can be on site and be available to offer legal services to people in need, and let alone do it on a pro bono basis. So hats off in Tokyo to that. I think that was a really major accomplishment, and the fact that the pro bono list got activated in Japan was kudos to the Japanese bar.
Oh yeah, what a compliment! Thank you very much for addressing this point. Yeah, it's there have been a lot of really hard groundwork by the Japanese lawyers. Yeah, so that's a really great point. And I got a question from the audience. The question is, wasn't this client and Tony did make the representation more difficult or easier? So I think, yeah, this is a really kind of interesting question, because due to the time pressure, Mr. So, I think you had a real difficulty in communicating with your client in this context, unless they understand the actual operation of the why the regulation was like that. You may have a difficulty in explaining this is what's happening, and we need to do this by within an hour or within 2 hours or something like that. So how did you, Mr. So, how did you communicate with your client, and did you see any kind of a difficulty in communicating with your client?
Yeah, contrary to your expectation, we didn't have any difficulties. We communicated through web meeting and email exchanges. And actually, our client is our attorney, and she's very responsive and easily to form accurate understanding of our cases and the legal point and the process. So we were very lucky to have a good client.
Good to hear that. And I got another question from Vicky right now. And the question is, has there ever been a situation where an Olympic arbitration caused a delay or postponement of an athletic event? So I think the Shoichi, you are the best person to answer this question. Has there ever been any delay or postponement?
Thank you for a question. However, in my knowledge, I do not have the cases which the Olympic arbitration called the delay of athletic event. But as you know, at the Beijing game, at first, the medal ceremony of figure skating was scheduled. However, the case is pending, so the medal ceremony was cancelled during the game. And due to this this occurrence, the one arbitration is registered before the ad hoc division at Beijing.
Okay, that's a really good segue to Mr. Jeffrey Benz talking about your experience in Beijing. So, Jeff, the floor is yours.
So I'm going to try to show a brief. Oh, can I do screen sharing? Can somebody let me share a few slides?
Mr. So, can you drop? Yeah.
Let's see here. What am I? No, I can't share my screen. Oh, wait, let's see.
Yep. Go ahead.
No,
it's okay.
I'm not able to. Is it available?
No.
Oh, there we go. There we go.
Yeah,
Oh, me. Okay. Okay. Let me try to pull it off. Okay. So I'm gonna briefly talk about this, and everybody that knows me and when I talk, they're gonna be
So
like
Jeff,
cringing when I say briefly.
Sorry for interrupting. You know, the screen looks really kind of weird. It's only half of your presentation. So yeah.
Well, I'm known to look weird. Let me try it again.
Yeah, but you can go with this if you want.
Let me try something else. Let me see.
Yeah.
Any better?
Fantastic.
Okay.
Yeah.
So I'm going to talk about quickly the Beijing 22 CAS Ad Hoc Division, which I was privileged to be a member of. So every Olympic Games, the CAS, the Court of Arbitration for Sport, has a division that's on site that's available to react in real time to cases that arise. I'm going to talk briefly about living in the bubble, or what I call fondly daily diarrhea reporting, because that was among the requirements that we had to make every day, and none of us dared to lie about that. And then I'll talk really briefly about the cases overview, because there were a number of cases that fell into different categories, and I can't really speak in detail about them, but maybe in generalities I can. So the CAS Ad Hoc Division in Beijing consisted of arbitrators from those countries: the US, Italy, Slovenia, Ecuador, France / the UAE, China virtual, Denmark virtual, Australia virtual. I thought the most interesting thing was that the arbitrator who was virtual in China lived within a ½ kilometer of where we were all sequestered in the bubble. I won't go into any notions of how we might have broken open the bubble, but I will say that he and I have practiced law together. We had practiced law together at the same firm 20 years ago, and I have a very good relationship with him. And then we had a Danish arbitrator who I've been on a bunch of panels with, as well as an Australian arbitrator who I've been on a bunch of panels with, who were all virtual. And then the anti-doping division on site had a Swiss arbitrator and an Austrian arbitrator. And so that was sort of the dimension of what you got if you were confronted with a dispute as an athlete or anybody else in the sphere of the Olympic family on the site of the games. Here is a screenshot of, if you didn't believe it, the daily diarrhea report. Did you have a fever? Yes, no. Fatigue? Yes, no. Sore throat? Yes, no. Muscle joint pain? Yes, no. Chest pain? And then diarrhea right there on the list. So we had to fill this out every day for 14 days before we went to the games, and then every day while we were at the games. And if we didn't fill this out at the games, our COVID liaison officer was scolded about our lack of performance on the site of the games in Beijing. We also had to get daily COVID reports. I don't know how many people lied about the daily diarrhea question. Pretty sure 100%. I don't know, I don't know what it would be like to be in a Chinese prison if you were asked, well, what are you in for? Well, I lied on my daily diarrhea report. But it's part of the game. You have to fill this out. So on the right-hand side of this screen, you can see what welcomed us. I was literally the first person off the plane from Istanbul, which was one of the selected flight hubs to fly into Beijing direct from anywhere else in the Western part of the world. And I don't usually get greeted by people in hazmat suits. Usually there's like flowers. Well, I like to think there's flowers, maybe not always flowers, but definitely not hazmat suits and the like. And then over here on this side, on the left side of the screen, you'll see that this is where we got our accreditation. And oh my God, like they were completely suited up, thinking that we were going to infect them with our foreign COVID arrangements in some way. This was awesome, actually. This was the dining arrangements. You will see in the first slide, the first picture up top, there were dividers across every table. So we ate in cubicles if we tolerated this. And down below, you can see the side view. This system existed for probably about half of the games, and then there was slippage. And so by about halfway through the games, you could move this crap off the table at lunchtime. Breakfast you had to eat like this, but lunchtime you could eat, with this divided. And by dinner time, anything went. But up until then, the first 2 weeks, we were like learning how to sit diagonally from each other to have a meeting and have a discussion or just be social. Like it was like incredible. I had never seen this. We never had this in the US. This was an illegal picture. This is a photo. I had to go to the physician's office in the hotel. And this was illegal because they didn't have their face shields on, but they liked me and I liked them. And they're like, let's take a photo together and then we'll do the official photo. And they put one with the face guards on, and I didn't have a face guard on, but they did. And this was the illegal photo at the end of the day that it kind of enunciated what their view of COVID was and the protections should be. This is my favorite. So there was all this stuff at the Australian Open about where is Feng Shui. And so the day after opening ceremonies, there is effing Feng Shui right there. She sat in front of me and I had to move so I could get an appropriate photo to identify Feng Shui, the tennis player that apparently had been hidden by the Chinese authorities. But actually she was right there in plain view. And so there she was, and she showed up at a bunch of events, and I found Feng Shui. That was my claim to fame. I apparently, based on the Valieva case, I killed the Olympic Games. So I sat on the case involving the Russian 15-year-old who had tested positive for a heart-related medication. And if you believe the Daily Telegraph, I killed the Olympic Games. They died. And at the end of the day, the media misread the case. They misunderstood the case or didn't want to understand the case because the case was all about procedural due process and natural justice and what you're entitled to as a result of your participation in this whole system, not about whether she committed a doping offense or not. And who knows how her doping case is going to come out, but I would say that her entourage ought to be concerned. But Ms. Valieva, after the IOC put her in a remarkably difficult position of declaring that if she placed in the top 3 of the women's figure skating event, that she would cause nobody to get a medal, she appropriately finished 4th. So who knows what was really going on there and how that ended up, but it was an interesting story, an interesting part of my life. And I had media chasing me from when I'd get off the hotel elevator until I went into a sequestered place, be it a restaurant, of which there were limited options in Beijing, in the bubble, or until I went back to my elevator. And fortunately, I knew enough Chinese to tell them off at one point and shock them with my Chinese knowledge. But it's what it kind of is, and that was the story of the games. And keep in mind that story is not over. So she's going through her process. She's going to get her due process. We'll see what happens. I think at the end of it, I'll say thank you, and I'm open to any questions within reason on Valieva and anything else. Thanks for having me here.
Thank you, Jeff. I'm not going to the particular case of Valieva in detail. So I just wanted to focus on the procedural matter under the pandemic. But Jeff, based on your experience, of course, thanks to the technology, arbitrators of ad hoc division can be now virtual. But have you had any difficulty involving virtual arbitrators? So I'm not sure if you had particular case working with virtual arbitrators, but have you seen any kind of difficulty or maybe opportunities for the future, like in terms of joint work between arbitrators on site and virtual arbitrators?
So I think that we sat around in the arbitration, the international dispute resolution community, maybe not so much in sport, but on the commercial side, we sat around for a decade before the pandemic. And we debated this, that, and the other thing, and what about online dispute resolution, and what does it mean? And within a very few conflated months of the pandemic, on the commercial side at least, the world came to reality about what commercial dispute resolution could look like in this environment. So in the early days of the pandemic, let's say March, April, May of 2020, on my commercial docket as an arbitrator, I would regularly receive client requests that we put off the case to be heard in person until a date in the future, because this case needed to be heard in person. It had to be heard in person. It was so special. It was unique. And what we came to learn was that by May or June of 2020, in the commercial dispute resolution environment, the lawyers understood they weren't going to get paid. The parties understood they weren't going to get their disputes resolved. And the neutrals already knew back in March that they weren't going to get paid unless all of this kind of came together in a way that would reflect the new reality. And many of the arbitral institutions had built up what I would say is a bit of a, I don't want to say it too broadly, but a bit of a real estate play, right? We have hearing centers in the right places at the right time for what you need that can facilitate your disputes. And you can pay for that in addition to paying for dispute resolution services. And then suddenly they had to shift to investment in online dispute resolution in a variety of ways. And so JAMS, which is a provider I'm affiliated with generally, has done now thousands. I don't know how many thousands at this point. I've stopped like trying to track the stats on that, of straight online arbitrations. And honestly, the system was doing this kind of in a hybrid way before. So you had some witnesses remote or other witnesses remote, or sometimes an arbitrator would be remote or a lawyer. Anyway, it was toying with the system, but but the pandemic drove us all to the point where, honestly, I believe that we've made access to justice and access to cost-effective dispute resolution a reality on the backs of platforms like Zoom and WebEx and others. So I think it's really been an eye-opening experience for everyone that's in this business, and I think it will continue. I hope it continues. It's more cost-effective for the repeat players, the companies that constantly get sued, the entities that constantly get sued. They don't have to, their CEOs always available for their testimony now from their home office. They don't have to fly halfway across the world for a break in their schedule that might be 4 days or 3 days. Now they can do it in a matter of hours, and nobody has to pay for arbitrators to fly around the world. But there's still cases where fact-intensive questioning of witnesses might be useful, might be important, and the parties should be able to try to establish that, and the arbitrators ought to be able to consider that in terms of setting what they think is a reasonable hearing approach.
Yeah, so of course, many people are getting used to the online procedure, so it's a good thing, as you said. But at the same time, of course, we need to address the kind of pending issues in terms of the procedural justice regarding the online hearing or online procedure. So Jeff, may I ask you about the what are the pending issues in terms of procedural justice? So it's kind of a frequently asked question, but maybe, for example, testimony can be easily biased online. Maybe we can't exactly see what's happening with the testimony online. So have you seen, or do you see any kind of pending issues to realize the procedural justice regarding the online system?
So I think the main concern with pretty much arbitration generally, right? But even if it's not purely international, but even under the U.S. Federal Arbitration Act, every party has to have the right to have an equal opportunity to be heard. And how do you make sure that happens? And there have been a variety of ways suggested through all of this. Some of them, I would say, more theoretical than practical. But the reality of online is, what are you looking at right now? For good or for bad, you're looking at my face. And it's framed in a screen that's defined, and you can, if you make people turn off backgrounds and you make them sit in an environment that they're testifying about facts that are real without any influence, you can generally demonstrate that. And I don't think fact finders as arbitrators are improved by that experience in person versus that experience online. I actually have kind of adopted the online technology thing as a cost-effective way to resolve things. There are issues, for example, about how hearings are viewed, how formal they're viewed, what formality there is, whether witnesses treat them with the appropriate formality that might need to be managed. I mean, I had a case, a commercial case, not sports, involving significant issues, like in the big scheme of things, multi-billion-dollar issues involving the sale of used automobiles in California. And I had one witness, and I had to say to the lawyers, do you realize that we had 2 witnesses testify from inside of 3 cars in a case about cars? Like, holy crap, like this has changed sort of the formality approach to what it means to testify. And there should be some limits on that. Like you should have to, I think you should have to treat the parties, the court, the arbitrators with a little bit of respect at some level, but At the same time, there's a tremendous benefit to the notion of access to justice and ease of access to justice when some poor athlete from Africa or South America or a remote area anywhere in the world can appear on a case now, and it's well accepted they can appear like this. They don't have to fly all the way to Switzerland or to Los Angeles or wherever their hearing is going to be, and they can appear like this, and it's accepted as credible, possible, and meaningful.
Yeah, that's fantastic. Thank you very much. So to conclude this panel, I'd like to ask you the same question, Shoichi and So, regarding the pending problems or the major takeaways based on your experience. So Shoichi, have you seen any kind of pending issues to be solved in the future based on your experience, in terms of operation of the procedure? Is there any kind of a pending issue?
Yes, from the perspective of a staff of Japan Sports Arbitration Agency, I saw sometimes the person in the hearing room send a chat message to the witnesses in virtual, or I doubt some witnesses read script maybe in front of his or her screen. So for the fairness of the procedure, we really are taking care of the procedural fairness. So recently, Japan Sports Arbitration Agency is hold hearings in Japan International Dispute Resolution Center, where CAS Ad Hoc and Anti-Doping Division during the Tokyo Games said, and it had good facilities or equipment. It can several camera in the hearing rooms, and one camera can show around entire rooms, and the other camera is the face of witnesses, and the arbitrator instruct the witnesses or parties to load their camera or personal computers. To do that, we ensure procedural fairness. So I think the important is technology or the quality of equipment.
Fantastic. Thank you very much. So, Mr. So, do you have any opinion about this issue? I mean, pending problems for the future improvement.
In my case, in hindsight, I should have made more effective arguments by introducing witnesses for my side. But I thought we could take advantage of the virtual meeting to introduce the witnesses. But at the same time, I thought it would be very challenging under the limited circumstances, under the limited timelines of the ad hoc division cases.
Okay. Yeah, thank you very much. This is really interesting. So, so time is up. I think we need to conclude this panel. So, do you have any kind of a final comment, Jeff?
So I think the development of online dispute resolution is ongoing, and all of us as professionals in this area have the ability to shape it, form it, and make it what it might ultimately be. I think it has tremendous potential, and I think in the accelerated time environment of sport, the virtual hearing process is a necessary and important development that will make us more effective in getting our clients' disputes resolved in a meaningful way.
Yeah, fantastic. And to wrap up this panel, Jeff, please make a greet to Japanese audience in Japanese.
Okay, so my Japanese is not good enough anymore. I'm out of it. I've converted, but I'll say, domo arigatou gozaimashita.
Oh, fantastic. So, Jeffrey, you are the key person who realized this relationship between SLA and the JSLA. And I think we had a really good panel, good first panel. So I think, continuing this type of joint event will be really good for both of us. So, yeah, Jeffrey, thank you very much for making this happen. And this is the end of this panel. Thank you very much.
Thank you. I agree. Arigatou.
Thank you.
Thank you.
じゃあまた。